Okay, I think we'll get started. Welcome, everyone. My name is Michael Gerard. I'm a professor at Columbia Law School and the faculty director of the Sabin Center for Climate Change Law. I'm pleased to be moderating this panel, but we're going to start with Enéas Xavier de Oliveri, who is with us remotely from the University of Montreal. So Enéas, I'm going to turn it over to you to introduce the topic of today's program and to introduce all of our speakers.
Professor Michael, thank you so much. Ladies and gentlemen, good evening. Welcome, everyone. It's an honor to participate in the International Law Weekend. We thank the American branch of the International Law Association for organizing such a marvelous event, as always, essential to the development of international law. Without further delay, please allow me to introduce the following panel: the role of international courts in promoting states' responsibility for climate change. In the past decades, the international community has struggled to conceive a strong framework to curb climate change. Despite the treaties concluded and the agenda adopted, such as the Paris Agreement and the universal participation and engagement of all countries in the climate debate, it is fair enough to say that we have failed so far to deliver the proper answers to avoid the climate crisis that has already taken place. And it is hard to conclude otherwise. Scientific evidence states that the global average temperature continues to rise, and we are facing extreme climate events. The Amazon forest is a good example, and as a Brazilian, I cannot miss the opportunity to mention that the Rio Negro in the Amazon forest, which is the 7th largest river in the world in volume of water, just went dry, as simple as that. More than 60,000 people died in Europe 2022 due to circumstances related to heat waves. And this year, it seems we broke every record of high temperatures. The acidification of our oceans and the elevation of sea level are a concern, as well as the migration flows of millions per year because of environmental and climate conditions. This is our reality. And some of these impacts on nature and human systems are already considered irreversible. And we see the loss of human lives and the escalation of human rights violations. If we still wish to keep the temperature rise to 1.5 Celsius degrees, we should be seeing clear movements of the international community toward a decrease of 45% in greenhouse gas emissions by 2030. But instead, the latest report published by the UNFCCC points out an increase of 11% of greenhouse emissions. And the financing for developing countries is way behind the necessary. Well, this failure has led to the phenomenon of climate litigation before international bodies. The past 12 months alone have seen groundbreaking requests for advisory opinions from the International Court of Justice, the Inter-American Court of Human Rights, and the International Tribunal for the Law of the Sea on states' responsibilities and obligations for climate change and its impacts. Advisory opinions carry great legal weight and moral authority and could be an important catalyst for the urgent ambitions and equitable climate action that is needed to stop global heating and to limit and remediate climate-induced human rights harms. However, the international community has a responsibility to ensure that they partake in the advisory opinion proceedings to ensure that the outcomes reflect a global perspective. And that's exactly why we are here to address the circumstances, hoping to deliver substantial thoughts and insights for the development of international law. Now, please allow me to introduce our panelists. We count on the very special and unique participation of highly qualified panelists coming from different parts of the world, each one with its own expertise, working together for a better understanding of such a challenge to humanity. Allow me to introduce Miriam Cohen, who is an associate professor at the University of Montreal and holds the Canadian Research Chair in Human Rights and International Justice. She's the author of Realizing Reparative Justice for International Crimes, recipient of the 2022 Scholarly Book Award from the Canadian Council on International Law and a Quebec Bar Association Foundation Award. She is part of a team submitting an amicus brief to the Inter-American Court of Human Rights on the climate change advisory opinion. She previously worked at the International Court of Justice and the International Criminal Court, and has acted as counsel before the International Tribunal for the Law of the Sea and the Supreme Court of Canada. She is vice president of the Quebec Society of International Law and member of the board of the Canadian Council on International Law. Her work focuses on public international law, international human rights law, transitional justice, as well as climate justice, and the law of the sea. She's a member of the Quebec Bar and an accredited mediator. Michael Gerard is Andrew Sabin Professor of Professional Practice at Columbia Law School, where he teaches courses on environmental and energy law and founded and directs the Sabin Center for Climate Change Law. He has a joint appointment to the Columbia Climate School and is a former chair of the faculty of its predecessor, the Columbia Earth Institute. Before joining the Columbia faculty in 2009, he was partner in charge of the New York office of a large law firm. He practiced environmental law in New York City full-time from 1979 to 2008. He was the 2004-2005 chair of the American Bar Association's 10,000 member section on environment, energy, and resources. He has also chaired the executive committee of the New York City Bar Association and the environmental law section of the New York State Bar Association. Gerard is the author or editor of 14 books, 2 of which were named Best Law Book of the Year by the Association of American Publishers, Environmental Law Practice Guide, and Brownfield's Law and Practice. Among his other books are Global Climate Change and U.S. Law, Threatened Island Nations, Legal Implications of Rising Seas and a Changing Climate, Climate Engineering and the Law, Governance and Liability for Solar Radiation Management and Carbon Dioxide Removal, and Legal Pathways to Decarbonization in the United States. Niloufar Oro is the director of the Center of International Law at the National University of Singapore, member of the UN International Law Commission, co-chair of the study group on sea level rise in relation to international law, chairperson of the 4th session of the ILC, associate member of the Institut de Droit International, climate change negotiator for Turkish MFA 2009-2016, appeared before the International Tribunal for the Law of the Sea, distinguished fellow of the Law of the Sea Institute, UC Berkeley Law, member of the Committee of the Law of the Sea Institute, member of the legal experts of the Commission of Small Island States on Climate Change and International Law, steering committee of the IUCN World Commission on Environmental Law, series editor of the International Straits of the World Series, member of board of editors of several academic journals. Dr. Christopher Ward is a senior counsel of the New South Wales Bar in Australia and associate member of the 3 VB barristers in Gray's Inn, London. He holds an appointment as honorary professor at the Australian National University and publishes and teaches extensively. He's a former president of the International Law Association. He works globally as an advocate in all aspects of public international law and has a particular interest in the law of the sea, including the legal framework relating to climate change and deep sea bed mining. He has advised and represented states and NGOs on questions of climate change, Scope 3 emissions, and related litigation strategies. Claire Streedom is a project coordinator for the Center for International Law and Policy in Africa and is currently working alongside Professor Charles Jallow and Professor Phoebe Okawa in the representation of a number of African states for their submissions in the International Tribunal for the Law of the Sea, and ICJ, the International Court of Justice, Climate Change Advisory Opinions. Claire is also currently the Secretary of the South African branch of the International Law Association, where she launched the Network for Young Scholars and Practitioners. Her scholarly work and publications are mostly grounded in international humanitarian law and international law as it applies to emerging technology, with a special focus on Africa. Other fields of interest and work include international criminal law and environmental law. And me, IACtHR, I'm a Brazilian environmental lawyer, and I have worked in the past 15 years with non-governmental organizations in legal fields such as international law, environmental law, climate change, environmental litigation, civil society empowerment, and participatory democracy. I'm a PhD candidate at the University of Montreal and a researcher at La Clima, Latin American Climate Lawyers Initiative for Mobilizing Action, and at the NETI USP, Center for the Study of International Courts at the University of São Paulo's Faculty of Law. My work and research focus on civil society participation in the United Nations conferences on climate change, the monitoring of climate negotiations, and the enforcement of the states' engagements to tackle climate change. I have recently contributed to the development of written opinions submitted by law school clinics and other organizations to the Inter-American Court of Human Rights. Thank you for this moment, for this introduction, and please, Michael, you have the floor.
Thank you very much. So there are climate change questions now pending before 4 international tribunals. First, the International Court of Justice. In order for this kind of case to get to the ICJ, it's necessary to have a majority vote of the members of the United Nations General Assembly. About 10 years ago, Palau and the Marshall Islands attempted to present such a question to the ICJ, but the United States actively opposed it, and the vote never took place. But about 3 years ago, a group of students in the Pacific decided to organize and try to get to the ICJ. They persuaded the government of Vanuatu to present a series of questions, and the UN General Assembly approved the motion to send these questions to the General Assembly. They did it by consensus this past March 29th. The court has set a briefing schedule where the briefs are due on January 22nd, and the reply briefs are due on April 22nd. Chile and Colombia presented a series of questions to the Inter-American Court of Human Rights. They made that submission in January of this year, and the court has established a briefing deadline of December 18th of this year, and I anticipate that they'll be setting up oral arguments probably in 3 or 4 locations around the region in 2024. Before the European Court of Human Rights are actually 3 relevant contentious cases. They're not advisory opinions, but they raise many of the same issues of state responsibility as these other, as the advisory opinion cases raise. The court heard arguments in 2 of these cases on March 29th, and the third just last month on September 27th. And finally, the Commission of Small Island States presented a series of questions to the International Tribunal for the Law of the Sea. They made that submission last December, and the tribunal heard 2 weeks of testimony in September. And so it is likely that 2024 or 2025 we'll see a series of decisions from all of these tribunals that could cast considerable light, we hope, on the international law relative to climate change. So I'm going to pose a number of questions to our panelists. And first, I'm going to pose one question, which I'll ask all of our panelists to address, which is, how do you perceive the role of advisory opinions from these international courts and tribunals in shaping discourse and, more importantly, action on climate change? And in particular, do you think that these cases may lead to a new framework for assessing state accountability and liability in cases of climate change harm? And do you think that these may change the legal landscape wherein we see more frequent challenges to state action and inaction on issues of climate change? So I'll start with Nilofer and ask you, and then go down the panel, and then I'll go to the people on the screen.
Well, thank you. Thank you so much, Michael, and thank you to the organizers for inviting me. Does this work? Do I need it? Can you hear me? Mm-hmm. Yes? Okay.
I think the people on the screen need you to be holding the microphone.
For that, okay. For being on this panel. And right now I apologize for any incoherence because I flew 18 hours from Singapore this morning. So I'll do my best to answer these questions, which are very important. The role of advisory opinions, particularly in the context of climate change, I am someone who looks at it very positively. I know there are some colleagues and scholars who tend to be a little bit more, I don't want to say skeptical, but may question it. The fact that we have 3 advisory opinion requests speaks loudly in many ways that obviously there are states who do believe that the courts, international courts and tribunals can offer an important role, particularly in clarification. And just to give an example, my area, which is law of the sea, as wonderful a convention as the Law of the Sea Convention is, it was a pre-climate change instrument. And so there are questions, and we can answer these questions as scholars, or we can debate, but to have a tribunal or the ICJ or other courts bring clarification to states, we hope would actually facilitate states in understanding what their obligations are and actually take the necessary legal, administrative, policy measures. So in the sense that it shouldn't be framed in just holding states responsible. I think it also has to guide the way, shine light, because we need to meet that 1.5 degrees. It's absolutely urgent. So we've gone the politics way, the COPs. There's domestic litigation, which I'm sure we'll talk about that. But the international level is very important. And I think the high level of participation by states at the ITLOS speaks very well. And one thing, if I can say about advisory opinions as well, and I think in climate change, it's really come out of hamper. It's very democratic because in contentious states, cases, it's only between two states. But advisory opinions, it was 40, I don't know, I really didn't count how many states actually submitted written statements and then appeared in hamper. So in my view, there's a very important role for advisory opinions. Yes, not binding, but has great authority and for clarification of what those responsibilities are by states. And hopefully states will take this seriously. And of course, based on the assumption that we will have robust opinions coming from the tribunal reports as well. So I'll stop here and allow my colleagues to continue.
Thank you, Miriam.
Thank you. So let me first start by thanking the organizers for inviting me to participate. I'm very glad to be here and to share some thoughts. So building on what you just said, there's also this idea of the impact symbolic, right? So I see it as you have the legal impact, and you've already mentioned a lot of the legal role of these advisory opinions. there's also this symbolic impact, and the symbolic impact can be seen from different perspectives. So there's this momentum of having this trio of advisory opinions. So in different areas of international law, so law of the sea, state responsibility, International Court of Justice, but also human rights and the environment, human rights and climate change. So this momentum brings light to the urgency of the crisis, right? Where before we had the negotiations, it was very diplomatic. We started seeing some domestic proceedings and litigation that often it's very hard to find information. And now we're beginning to get more and more databases and information that are very helpful for us to kind of map all these domestic cases. But having these three cases internationally addressing this question that it's a very big, important, broad question of climate change. You can't just address it from the perspective of human rights or from the perspective of public international law or state responsibility. There's the law of the sea, marine environment, and so forth. So I think there's also a second kind of symbolic impact, and that impact is the participation, right? So if we think about, I'll give the example of the Inter-American Court and the level of participation, we can't have exact numbers yet because the court has already extended the deadline, which probably means that we're going to have what we all are expecting a very large number of participants. And I think, to me, this is a very positive development. In advisory opinions, we have this possibility of having broader questions that are not really attached to facts of the case, and having the possibility, as we saw at the ITLOS, and as I think we'll see even to a greater extent at the Inter-American Court, where we don't only have the scientific and the legal arguments, the scientific evidence, but also those that are impacted by climate change are able to participate, particularly at the Inter-American Court. So I think that's very important, this idea of like inclusive participative justice. Climate change is not a kind of an interstate bilateral case at all. You know, it affects everyone. It affects every country. It affects people differently, and we see that. I think it's very clear now from the evidence that there's a disproportionate effect on different communities. So the fact that they can go and you know have their day in court and also explain to the court, but to a broader audience, how it impacts the youth, the vulnerable people. I think it's a positive development. In terms of the sort of legal impact, I mean, we can go on and on. So I'll just focus on one point. I think that the fact that you have these three advisory opinions that are kind of in parallel allows us to have really a broad view of what climate emergency is, right? So it's not, like I said, just a question of, you know, what is the accountability, responsibility of states, but for example, what is the relationship between human rights and climate change, and how can we have action for climate change that takes into account human rights? So if we look at all the questions that have been posed in these three advisory opinions, we cover quite a number of important questions. And I think once we have all of those opinions, we'll have a lot of clarity on some of the questions that before, perhaps during negotiations, were not yet addressed, or at least you know, we didn't know much about them. So I think I'll pass it on to my colleague, Christopher.
That's better now, sorry. Look, I think, as Mary says, the real strength of these advisory opinions running in parallel is the provision of a voice. As I said in my speech last night, it's the provision of a voice to particularly the smaller, most affected states that haven't previously been able to, I think, in a coherent, collective way, articulate their concerns and gather the attention of the international community at large. And diplomacy can only go so far. So the advisory opinions running in parallel has a particular power to it. There is, of course, the risk, and there is a risk that the opinions might be, for want of a better word, equivocal or underwhelming. And that is always a risk in any form of litigation, including advisory opinion litigation. It's possibly less likely than some of the critics might think. I'm encouraged, for example, by the fact that the Committee on the Rights of the Child gave a very strong opinion, although dismissing on jurisdictional grounds for failure to exhaust local remedies, but gave a very strong opinion on the merits of transboundary harm and climate change. I think that it's very likely, given the overwhelming weight of the opinions that are being submitted to particularly ITLOS and the ICJ, that those respective tribunals will make positive findings about the substance of the disputes. And I think, as Nilufer says, what we're trying to do with those cases is fit into a square box, a round circle. That is, we're taking a problem that didn't exist when many of these legal frameworks were established and trying to squash the problem of climate change into language of pre-existing treaties. Now, that said, I have a particular view that, for example, the language of ITLOS does extend fairly clearly to carbon-based pollution, and the detail of those arguments is well established now in the submissions before ITLOS and the court. I think the advisory opinions are likely to clarify thinking around those legal problems, and that, in terms of the effect of the advisory opinions in particular, I think that will have a very substantial effect on the cross-fertilisation of those legal norms into the domestic sphere, and particularly before domestic courts, because in parallel to these international proceedings, and we'll talk about later, but in parallel to these international proceedings, there are numerous examples now of domestic courts around the world of domestic litigation being kicked off by particularly affected individuals and interest groups. That's happening in many domestic legal systems with various degrees of success. But I think the impetus of advisory opinion work will inevitably have an effect upon the way those domestic cases run. So I think that's all I'll say at the moment in relation to the first question. But thank you, Mark.
Thank you. Clea, we'd like to hear from you.
Sure, thank you, Michael. And I apologize for not being there in person. It was my plan, but unfortunately, COVID got me post-pandemic. So that's why I'm joining in remotely. So I agree with everything that's been said up to now. I think this is a momentous opportunity. But I do want to emphasize, and this has already been mentioned, that the importance of state participation, the importance of state participation. You know, in order to lend additional legitimacy to the outcomes of the advisory proceedings, we really need the representation of a spectrum of states. Otherwise, international law on climate change could develop without really including the perspectives from regions most impacted by climate change. That said, I am very optimistic. You know, just speaking from African states' perspective, the involvement in the ITLOS advisory opinion, there was a massive uptick compared to previous advisory opinions from the tribunal. You know, I mean, relatively, it's still only 6 states in the African Union that submitted written statements, with one of them being after the deadline. But this is still, you know, compared to previously, where, you know, only really Somalia submitted written statements. And we really hope this momentum will carry forward into the ICJ written submissions. But there is, of course, this correlation. You know, the reason that African states or small and developing states don't participate in these proceedings is often a reason of capacity and resources and, you know, other priorities. But then the correlation is, of course, these states are also more affected or bear the brunt of climate change, and they can't really mitigate and adapt because of capacity and research. So, you know, that's something that we hope that is really addressed in these advisory opinions. And I think this is a fantastic opportunity, especially for the more, you know, if we talk about the legal impact, the more discretionary provisions in UNCLOS and in the climate change regime, for the courts to really give more concrete clarifications of what is expected of states. You know, and as Chris said, of course, there is the danger or the risk that courts are overly cautious and being not to be overly prescriptive. But I think because of the importance of the situation, I am hopeful. And I think it's just, especially with the ICJ case advisory opinion, this is really an opportunity to look at climate change holistically, and not just in terms of the climate change framework, but also incorporating human rights and UNCLOS. And it was very interesting in the ITLOS proceedings and the written submissions and oral submissions, despite it being just in terms of the convention, how often human rights was addressed and the impact of climate change on human rights. And I'm really interested in to see how that body of law develops going forward. Thank you.
Thank you. Aeneas.
Oh my God, what else can I say? After all these contributions, I do agree with the colleagues, and I'm an optimistic professional, even though sometimes I end up disappointed. I can, for example, mention in 2010, I was a LLM student at the time that International Court of Justice delivered its decision on the bone meal case between Argentina and Uruguay. There was an expectation that was it was not matched. For example, yes, the court delivered a substantial provision on procedural obligations that were breached by Uruguay, but that was pretty much it. The court didn't go any further. But I do believe right now we face a very unique moment, and specifically, I have seen the proceedings in the ITLOS, many arguments that interconnect sea pollution with climate change, and also in the Inter-American Court of Human Rights, climate change and human rights. So these arguments, I think, will provide the courts to deliver a substantial decision, specifically concerning the Inter-American Court of Human Rights. The court has already delivered substantial decisions on, for example, the rights of indigenous people to hold their traditional territory. And we have some other decisions, soft law decisions, that the court could give some binding force. For example, we have the targets within the GBF, the Global Biodiversity Framework, that determines that indigenous people must hold their traditional lands as a way to conserve biodiversity, or that we should restore and protect our environmental areas, 30% of it. So concerning these subjects and others, for example, environmental defenders, I think the court will be able to deliver substantial decisions through the adversarial opinion. Thank you.
Thank you. So all three of the requests for advisory opinions were brought by countries in the Global South. And two of them, the ICJ and the ITLOS, were brought by small island states. The ICJ opinion was sparked by students in the Pacific, and one of the three contentious cases pending before the European Court of Human Rights, the Duarte Agostinho versus Portugal case, was brought by 16 young people in Portugal, saying that all 32 of the state members of the European Union contributed greenhouse gas emissions that added to the wildfires that devastated parts of Portugal. And let me start with Nilofer. What do you see as the significance of who the parties who are the parties that are bringing these cases? And do you think that has positive impacts? Do you see any downside to it in terms of international acceptance?
Yeah, thank you very much for that question. And it's an important one because I think the fact that these cases particularly the ICJs and the Portuguese Vanuatu case, where the ICJ has been brought by young people, is so important. And I think as international lawyers, we should rejoice that young people actually have faith in the international legal system. And to me, that is something that we shouldn't, I mean, I don't think we can undervalue that, the importance of that. And when it comes to also the role of the Global South, again, what does this mean? Obviously, the international judiciary system is seen as a place where perhaps the weaker states, those who have been most vulnerable, particularly in climate change and least responsible, feel that they have a voice, where they have equal representation. And I take in particular the case of the small island developing states, the Pacific Island states. They have really played a tremendous role in pushing the climate change agenda. And I know in the UN, but particularly now with these cases, you mentioned Palau. So we've come a long way since that. And I think, well, it might also be because climate change has become so much more urgent as a request. So in general, I would say that it's very significant that you have young people, that you have countries from developing countries, particularly those who are least responsible and are going to suffer disproportionately. And they're looking to international law, and they're looking to the courts and the tribunals to get redress, or at least support for that. The only downside is we don't get, the expectations are not met. And hopefully that will not be the case, because then it's not just they'll be disappointed, but for international law, it's a great opportunity to show how international law is relevant. It can make changes, and I think we really need to give that message very strongly. So I'll just stop there.
Aeneas, did you want to address this?
Thank you. I think there's a clear message that we can make the difference here. Climate change is such a hard subject to address, and it's because usually the most vulnerable are who contributed to climate change the least. And the Global South is usually fond of these political arenas, because in the Hobbesian scenario, we cannot make it by the use of force. We cannot make the difference economically. We are victims of a system that it's hard to move along and to make a change. But within the context of equal powers, yes, we can make the difference. And it's fantastic to see that a group of students have initially provoked this adversarial opinion request. And that's the hope that we have, that through adversarial opinions, we can develop the international law response to address climate change in a proper way, where the needs of developing countries and the most vulnerable are met.
Would any of the others of you like to address that? Marion?
Perhaps just very, that's very loud. So just very quickly, I think it's important also, just kind of from the broader perspective of international litigation and advisory proceedings more generally, that it comes from Global South, developing countries, the youth, in the sense that we have to look at international law as like, it's not an international law for just interstate and the global north. And I think it will frame the way that the different courts and the tribunal will look at the question. Coming from a youth group and coming from small island states, the courts they cannot not see the question from their perspective as well. So I think it's extraordinary. I agree with what my colleagues have said. I think it gives us all hope as as just humanity that people are taking things on their own hands and they're trying to make a change. And I think it will have an impact on the actual outcome of the decision because it's putting it out there for the court. There's a real impact on us, and you have to address that. So there's no way around it. Essentially.
And Michael, if I may, I agree with that in this way. In fact, a member of my chambers is one of the council team representing the plaintiffs in Agostino against European Union and Portugal. It is significant that youth groups are driving much of this litigation, both in the international context, but also domestically in various cases around the world, because all courts inevitably treat young people as a especially vulnerable cohort and approach litigation involving children with more respect than they might otherwise. And that, perhaps even in an intangible way, but that plays into the way the litigation is being treated, I think, respectfully at all levels, domestic and international.
Cleo?
Yeah, I mean, I agree with everything. I would just really like to emphasize and echo again what was said regarding international law and this being an opportunity for international law. I think international law, with everything that's going on in the world, is facing a bit of a legitimacy crisis. And I really believe that this is an opportunity for the international community to come together on one hand, but also for international tribunals and courts to show that they are working. International law still works. It can still hold states accountable, and it still can create or interpret the law effectively. And it will be the downside, as was already mentioned, is if it at all seems that they're pandering to more powerful states, or if it all seems that their hands are tied or anyway, or then they're not willing to robustly answer the questions, then there will be a legitimacy crisis. And I think, smaller states and developing states may further lose faith in international law.
Thank you. So these advisory opinions that are awaited will barely be advisory. These tribunals don't have the power to force states to do anything in particular. They don't have enforcement power. Domestic courts do. And in recent years, we've seen several decisions from domestic courts around the world that are actually ordering their governments to take action. The most prominent of these was the Urgenda case from the Netherlands, and we're awaiting the appeal in another case from the Netherlands against Shell Oil. We've seen decisions from domestic courts in Germany and France and Nepal and Brazil and Colombia. And several other countries that are using various doctrines of sometimes it's international law, sometimes it's domestic constitutional law, sometimes it's relying on human rights law. Most recently, we have a decision from a state court in Montana in a lawsuit brought by young people in Montana with these. So my question is, do you see these advisory opinions, if they come out the way that many of us hope they will, having an influence on domestic courts and driving more serious action in those countries where the domestic courts really do have the powers? Who would like to start?
Look, I'm happy to go first and say yes, of course they will. Of course, international advisory opinions, although not binding, carry persuasive weight. They always have, and they always will. And there is something magic about the legitimacy of a court or tribunal articulating a legal principle that goes beyond the exact same articulation of the exact same principle by civil society and the academy. Courts in international tribunals, even in strictly dualist nations, carry significant persuasive effect. And for want of a better description, they provide cover for domestic judges who are able to shape either civil law or common law in particular ways. They allow judges to progressively develop domestic law in the absence of clearly inconsistent statutory provisions. in ways that do justice. And so I think that these will be very powerful decisions, as we say, assuming they do the right thing.
Anyone else want to chime in on that?
Yes, I am. Sorry, go ahead.
No, please go ahead.
Okay, Leah, go ahead.
Okay. Yeah, I agree with Chris. I think, and this really actually then also, it might depend on the domestic legal framework in terms of, how judicial decisions are viewed as sources of law, or subsidiary means for the identification of rules of international law. But I absolutely, and from a South African perspective, South African courts, especially the constitutional courts, but also lower courts, have a tendency to refer back to ICJ decisions, international tribunals, on all matters. And I think what these advisory opinions do, and as Michael said, they're not binding on states, but they do create a body of law that can be referred back to. For example, there's currently in South Africa a case that's just been postponed about Shell operating on the west coast of South Africa, oil exploration. And that's been delayed to next year. And I think if these decisions could have a massive impact on that. And I think that's where the real value lies of the advisory opinions. Thank you.
Yeah, so I'll just add to that just a couple of brief points. I think there's also what everyone has said, I agree, and there's also the idea of just empowerment, right? Like seeing these decisions if they come out, or the opinions if they come out the way we hope, and if, at a minimum, they give clarity to some of these questions, then it might empower even more litigation that is already quite active at the moment in different countries in the world. But the applicants might see this as, this is the opportunity. We have an opinion from the International Court of Justice, the International Tribunal for the Law of the Sea, regionally the Inter-American Court. We can use that as a platform, to build arguments and to go before our national courts. So there's that, and the second point I wanted to make is one that I've already mentioned before, which is the breadth of the questions, right? So that also might open different areas of litigation nationally by looking at these three advisory opinions consecutively, how much they will have covered all the different questions that they have to address. That might open up different kinds of litigation nationally that perhaps, within the bounds of each country and each legislation, what is permitted, but that might open up new avenues of litigation nationally as well.
Well, chime in as well. I agree. Obviously, it'd be very important if we have robust opinions coming out of these. They will certainly facilitate domestic litigation, which does have the teeth, obviously, and I think that is important. But I wanted to add one thing, and I believe Clea mentioned on Shell. A little bit under the radar that's coming up more is in the investment arbitration area and climate change. And I don't know, that's where I don't know, and that'd be very interesting to see if the advisory opinions could have an impact on those, because these cases may be less visible, but perhaps great impediments to states meeting their climate change obligations. And we know that there's this whole movement for leaving the Energy Charter Treaty, but there's a case against the Netherlands, $1 billion. There was one against Italy, $100 million award for basically not going through a project. So I think we have to look at these as well, not just the traditional contentious domestic cases, but these investment arbitration cases that are coming up more and more.
Thank you. So the largest greenhouse gas emitting countries in the world, of course, are China, the United States, India, the European countries collectively, and Russia. And these countries are all under pressure for greater ambition in their greenhouse gas reduction efforts. At the same time, loss and damage has become a much more important subject of international negotiations. And the US and some of the European countries, of course, are under a lot of pressure to provide money for loss and damage. It's not at all clear that the governments of China or the United States or India or Russia will actually care much about these international advisory opinions. If that is correct, and if these opinions don't move what they actually do in terms of their energy policies and their willingness to make contributions, what are the impacts of that on international law and on international relations? And do you think I'm being too pessimistic about the reaction of these governments to the decisions that many of us are hoping to see?
Look, I might get this and say, Michael, I don't think it's ever possible to be too pessimistic about the reaction of governments to international policies.
Can you use the microphone?
Yeah, but there are probably two responses to it on a more serious level. The first is the domestic will be the key. That is, domestic litigation does have teeth, and that will flow from international decisions. As Nilufer said, the fraught area of investment arbitration in this whole area is developing at a pace, including, of course, there's the Energy Charter Treaty arbitrations involving particularly Spain, which I've been involved with, but other European countries, which at one level sort of stymie and slow down progress, at least in the eyes of the states. And so there's a very delicate balance to be achieved there. But in terms of the enforceability of the advisory opinions, of course, they have their particular persuasive power and perhaps not much more. But I think that does not mean that they won't have a practical and serious impact sounding perhaps in actual loss and damage in indirect ways moving forward.
Anyone else want to chime in on that?
Well, I'll give it a go because it's a difficult question. Loss and damage has been an issue for a long time. Back in the Copenhagen COP for climate change, the developed states had made a commitment to giving developing countries, in particular, they don't use the word loss and damage, but what would be up to $100 billion a year, not total, but a year. And we know that that has not materialized. On the other hand, if I can be, I don't know if it's blunt, but we can see geopolitics coming in now. And I think those states you mentioned are willing to give support, but they may not call it loss and damage. And it may be used for, for different purposes in this geopolitical context, particularly in certain parts of the world. These states seem averse to loss and damage. On the other hand, there are commitments that have been made. China may not make a commitment per se to climate change, but I think they will make commitments to provide support for political reasons, actually. So maybe it's in the manner in which it's framed and the context. But I agree that loss and damage continues to be problematic, and yet it shouldn't be, because the fact of the matter is, if we don't give support to those states that are going to and are really suffering and from the adverse impacts of climate change, ultimately every state's going to suffer from it, whether it be displacement of persons. So it really, it's in every state's interest to actually support, particularly those who are the large emitting states. So I'll stop right here.
And of course, as you say, in Copenhagen, the developed countries said that they would contribute cumulatively $100 billion a year. Everybody recognized that wasn't nearly enough and that number would have to go up, but they're still not at $100 billion a year. So the mitigation gap, the adaptation gap keep on growing and growing and growing. So these cases are brought by a small number of countries. And can someone talk about what are the mechanisms for countries that are not parties to participate, and also the opportunities for civil society and academia and other organizations to participate in the arguments before and the deliberations of these bodies?
Any sort of thing?
Who would like to?
Online people.
Anyone want to? Clea?
Sure. Yeah, so I mean, that is of course problematic, and especially with states, and as I mentioned earlier, therefore, especially for smaller states, smaller developing states often don't have the capacity or resources to participate. They obviously, and this is something that we're trying to address. At least there is some funding available, and we're trying to encourage more states, especially from Africa, to participate. It is difficult though, because and this goes back to the argument of who makes international law. So is it just states, or is there room for civil society to be involved? So for the ITLOS, obviously, there were written statements delivered by certain organizations, for example, the International Union for the Conservation of Nature. And it was, of course, the case was brought by the Commission of Small Island States of Climate Change and International Law. And then there's also groups of states like the EU and African Union, especially with the African Union, while there were only 6 states that participated, other states might have felt represented by the African Union's arguments. But yeah, and then also I know, and I think Aeneas can answer to this as well, he's been involved with civil society that, were participating, and I think Miriam as well, if I'm not mistaken, so they can speak more on civil society engagement, which I'd be very interested to hear as well.
Erin?
Yeah, so this is one of the questions that really interests me, is how can we make this more inclusive, right? And it's always interested me, public interest litigation and, the 2 interstate courts, tribunals that we have, how close they are, and that this is a case that we can make them more open. So I agree that there are challenges, but I also think that there's a lot of positive that has happened with the ITLOS, and we see the amount of states that have participated. And there's a spectrum of participation, right? So the ICJ is pretty closed as to what parties can participate in an advisory opinion. And there's a lot of criticism in the literature about that. And especially in the case of climate change, we can really revisit this criticism. The ITLOS, there were a number of states that participated. And what's interesting there is even the parties, the participant that submitted briefs that were not included officially in the case file, they were available at the website. So I think that's kind of going to my point about how do we understand participation, right? If we understand that as a direct participation, formally participating in the proceedings, then there are definitely challenges, especially with the rules of procedure and the practice directions in the 2 interstate court tribunal. But there's also this kind of broader way of participating. So this kind of indirect way where civil society, individuals can participate through a state or by submitting briefs that are not even part of the case file, but that could be easily seen by the court. So I was part of once this discussion about how can academics even contribute? So, open access papers, write papers that provide arguments, that provide very solid research. And, these are papers that will be researched and found and might, in this broader way of understanding participation in this context, find its way to the opinion. And then just to end on the spectrum of participation, so you have the Inter-American Court, which is, I think, a very positive way of looking at climate litigation, where it's extremely, extremely broad, the participation. So any person, individual or organization can participate. And that's, Ines and myself are part of a broader group that have submitted a brief, and we know, as you probably also know, many different clinics or association or civil society individuals that submit briefs. And I think it will be a very interesting, rich opinion from the Inter-American Court that will have all these arguments and this contribution from not only legal experts and scientific evidence that might be provided in these briefs, but also individuals that are affected. Like I started today's session mentioning that. So yes, there are challenges, but I don't think it's that negative. It's not that dark. I think we've seen quite an improvement if we look at the way advisory opinions have been led in the past and how little participation there was. And I think we'll be quite surprised at just the sheer number of participation in the Inter-American proceedings.
Thank you.
Well, if you allow me, I don't think that the advisory opinion will completely solve the problem, but will certainly provide us guidance to reach some progress. Of course, it is important for civil society to be able to contribute with written briefs for the analysis of the case, but I think the most important is the day after. Okay, the court delivers the opinion and it's quite substantial and good. And what else? What's next? Within the Latin American context, we have the conventionally controlled doctrine. So we have things that happen with other subjects. Whatever is decided by the Inter-American Court of Human Rights, either in a sentence or in a contentious jurisdiction or the advisory jurisdiction, they have the power to change national policies. And so I think civil society will play a very important role in the day after, bringing cases in domestic courts to enforce whatever is decided by in the advisory opinion. So that's a key element that civil society cannot miss.
Just very quickly, I think Inez raised a very good point that the role of civil society is important, and it doesn't mean that civil society should necessarily be a party in these cases, although we have seen, and that was mentioned in ITLOS, the WWF and some others were allowed to be amicus curiae, and their papers are available. I'm a member of the IUCN, and we have Simi Payne here, my colleague, also is co-chair of the Oceans Group at the World Commission on Environmental Law, the IUCN, and we've always been invited by ITLOS to participate in the advisory opinions, all three of them now, and now ICJ also invited. So IUCN is an intergovernmental organization, but it includes hundreds of NGOs, actually. So it represents civil society. So it's rather exceptional. But I agree with Inez, absolutely. The next step, civil society has a very important role.
Thank you. So we have some time for questions. What I think I'll do is I'll take 3 questions at a time and then invite whomever on the panel would like to respond to any of them. So who has any questions? Perfect.
Thanks. Can I just speak without mic, or would you prefer?
Let me hand you.
Thank you. I'm Ingrid Chan. I'm an associate at Civi, but this is on my personal capacity. I'd like to know more about the topic just touched on about countries like China, Russia, in particular, how certain common themes like CBDR, common but differentiated, common responsibility but differentiated. The same theme has been kind of used in a different way between the African Union or African states on the one hand, and certain other countries in the global south. So I want to know the panel's thoughts on how to navigate the fact that the global south is not a monolith, and then there's a tension within it when it comes to the law.
Okay. Another question.
Yeah.
You know, I called on.
Oh, sorry. You got to direct.
Sorry.
For colleagues, I'm Gemma. I'm an advisor for the Development Mission, but last year I was on the Samoa delegation who negotiated the ICJ advisory opinion. When it was passed in March, one of the things we heard a lot of from delegations such as the ones you mentioned, China, Russia, the US, was the fear that the advisory opinion, the ICJ, would overshadow the work of the UNFCCC, where this was quote unquote rightly housed. How do you see that argument playing out at the ICJ in terms of claims of non-jurisdiction, but also at the same time, like this wide recognition that developing countries, the Pacific has been very progressive in how we've been using international law, and we are now talking about possibly starting the process for a new fossil fuel non-proliferation treaty. How do you see these multiple prongs of international law coming together, possibly merging, or how do you see them distracting from each other? Sorry that was so long.
Laval University. How much impetus do you think that the opinions will have on further international lawmaking relevant to issues of climate change? In particular, obviously noting the sea level rise, but we can think about other topics where potentially we could think about new ideas for international lawmaking, maybe to address some of the aspects, like for instance, reparations or others. You know, would that be? Do you think we can expect some impetus from these opinions for that? Thank you.
Thank you. So we have three questions, one focused on common but differentiated responsibilities, one on the effect on the UN climate negotiations, and one on the effect on international lawmaking. Who would like to address one or more of these questions? Oh, I have Mike.
Those are all very large questions, actually. But I did want to address the question you raised because it does come up in the ILC as well. But I would say this: the truth of the matter, loss and damage has been on the political agenda, as you know better than I, for a very long time. And it's not making progress. And the politics is separate from the law, the legal obligations. We do not have and so I think that has to be, that should not be an excuse. And frankly, states have not been, shall I say, living up to their responsibilities in that way. They've been, I mean, as I said, from Copenhagen, this $100 billion, nothing is happening. So promises, and at the end, what happens? You go to the adjudicated body. And this is an advisory opinion. So it should help states understand what their obligation is. CBDR is a tough one because they are not the same. This is something that is an important part of the climate change negotiations as well. CBDR is part of climate change law, but the Paris Agreement kind of changed things a little bit as well, where it said, okay, everyone has obligations to mitigate and that. And it's just a question of doing it differently, and the national determined contributions is an expression of that. But in reality, though, we have the large emitting states. And so the right to development, fine, but at the end of the day, if we don't make the 1.5 degree goal, that development is going to be highly imperiled as well. So that's all I can say.
Yeah, look, I think I just agree with what Developer said about differentiated responsibility. Certainly, I would add this: the issue of ultimate loss and damage being used as a geopolitical tool is a real issue. I won't, for the obvious reasons, say much more about it in a public forum, but it is an obvious and real strategic issue, which all states are aware of and all states are dealing with. I think the Global South is not a monolith. There are the vulnerable states and there are the large emitting states, and their interests are not the same. And that process is not necessarily a legal process. It's but the advantage of the litigious process is that it sheds light on the legal obligations, which can then be used in the diplomatic negotiations that follow, which I think is the next question, which I would just briefly address, and that is, of course, the advisory opinions, one way or another, will flow into the next round of diplomatic negotiations on future lawmaking, both internationally and, as I've said, domestically as well. That is an inevitable result of these opinions, whichever way they come down.
So I may
Go ahead, Claire.
We'll go with Clea, then Miriam.
Okay, sorry, Miriam. Yeah, I just wanted to add, and I think the question about common but differentiated responsibility was, if I understood correctly, is how do you navigate the different views of it, especially amongst developing states. And I don't know if I agree that those views are so different. I think it's more a matter of degree. I think all the developing states agree that there is common and differentiated responsibility, and that includes assistance to developing states. It's just really about how much assistance to developing states. But the CBDR principle doesn't mean by any means no responsibility. I don't think any of the states are really claiming that. And so I think, as was mentioned already, I think this is really opportunity for these states to express their views on the principle, and then find common ground, and also what works in practice and so forth. And then also, I just wanted to add with the impact of advisory opinions, as Chris already said, just like it would have an impact on domestic court cases, it will have an impact on domestic legislation. And, for example, with the International Law Commission, they have a study group on sea level rise, and, I'm sure they'll have topics in future that touch on climate change. And these advisory opinions will absolutely feed into those guidelines or draft provisions or conclusions that they create. And then there was one question that I just quickly want to touch on in terms of, I think there was a question about the different pathways. So you've got the Pacific, the fossil fuels ban or treaty, and then also, these cases and all these different pathways to state responsibility for climate change, or, corporate responsibility for climate change. And I think the question was whether, will be symbiosis or if they will disrupt each other. I would like to be optimistic. I think there will be symbiosis. I think it will take time, and I think it will depend on the timeline and how they feed into each other. But I think the more, the better, really. Thank you.
Miriam?
So yeah, very quickly. So for the question on disrupting or whether merging these different prongs. So I'm just speaking as an academic, right? So for me, you probably know more than me, but I don't think it's distracting. I think it's an excuse. I think it's a way to say, oh, let's just continue negotiating, right? Let's just go back on the table. We don't want something that comes from a court such as the ICJ telling what the obligations really are. So I think, as Clea just mentioned, the more, the better, but also just the clarity that comes from judgments, right? That can then be leveraged in negotiations. So I think it's actually a positive development for further negotiations for new treaties or to continue negotiations that are already in place and platforms that already exist. So I wanted to also address quickly the potential for international law making. So one question that you mentioned as an example is the reparations part. And I think we're kind of just, with the advisory opinions, touching the tip of the iceberg, right? We're going to eventually have to really think about, law of reparations under international law. How do we address climate change and how do we repair? So now we're talking about, general obligations and asking for clarity. And I am hoping that these opinions will also give us clarity on what do we do in terms of remedying, redressing climate change. So not only discussing obligations, but also the idea of accountability, right? So the three courts together, I think they can, come out of this by giving us clarity on the law, but also giving us clarity on what are the next steps. So how can we get redress for climate change and how can we think of reparations?
Okay, Aeneas?
Thank you. I would like to share an experience that I had in Montreal last year during the COP15 in the Convention of Biodiversity. One item of the agenda, which was climate change, the parties couldn't reach a consensus. So the negotiations were postponed to 2024. And the point of conflict was exactly common but differentiated responsibilities. The developing countries wanted the principle to be mentioned in the decision, but the developed countries refused to do so. And the argument was that this principle is not recognized as a general principle of international law. Point. And the developing countries argued that this principle is the foundation, one of the foundation of the climate change negotiations, and that a final text could not be delivered nor concluded without mentioning this principle. So I do believe, and that's an expectation, a high expectation that I have, that, for example, one of the courts could deliver and recognize that this principle, it is indeed a principle, a general principle of international law. Why not? Let me dream out loud and high. And another experience that I would like to share very quickly was, if you have the opportunity to follow the negotiations within a COP, please do it. And for example, China is the position that China was in the early 90s when they concluded the UNFCCC does not reflect the position that China finds itself right now in the political economic arena. And whenever a strong argument for a stronger engagement from China is brought on the table, their diplomatic representatives, they immediately intervene to say, oh, I'm sorry, I'm not here to renegotiate the treaty that was concluded in the early 90s, and I will not agree. Point. So I do believe that the courts, the tribunals, could deliver something substantial to move forward and to reach some progress on this matter. Thank you.
Well, I'd love to go on for hours more, but I can't. We're out of time. I want to thank our panelists for a very rich and enlightening discussion, and thank you all for coming.